So let's look at a quick case. This is old, but perfect illustration of a limited or low amount of damages, which might make the case non-pursuable in terms of how an attorney analyzes cases. It's a wrong site craniotomy that occurred in California. And basically, it was a child who had a brain tumor, and the team failed to mark the surgical site or take a timeout, which now are both standard of care. And they couldn't find the tumor and looked again at the films, realized they were on the wrong side. So they replaced the bone and repeated the procedure on the right side, and were cited by the Department of Health for violating multiple standards in the OR and had to institute a plan of correction. But in terms of damages, do you see why there aren't a lot of damages in this case? My point here in including this was to demonstrate in a way that you'll remember that if there aren't a lot of damages, then even if there's liability, the case will not be viable financially for an attorney to take to trial. I would say frequently medical malpractice cases cost at least $100,000 to even take to trial, and the attorney's fees are usually going to be contingent. And in this kind of a case, there was no permanent sequela from going into the wrong location. They didn't have to do any additional surgery because they figured out during the surgery that they were at the wrong location. And so there, other than a scar, um, which is fairly minor, there's not a lot of permanent injuries here. So if you're analyzing cases, it's important that you understand how the attorney's thinking about these cases. We have to be able to have a significant amount of damages, otherwise it's not worth taking. It's too costly.